Hello friends, this is Sanjay. In this series, we are covering constitutional law as per the standard LLB syllabus. If you started watching this series from somewhere in the middle, I would recommend that you should start from part 1 onwards. The latest PDF version of the Constitution is available at the URL on the screen. Download a copy and after every video, read through the relevant articles that we have discussed. If you have any questions or if you feel that I have missed covering something important, then post a comment and I will try to cover it in another video. In this part, we will be covering Articles 12 to 18, which are under Part 3 of the Constitution. During the discussion, we will be talking about what are fundamental rights, suspension of fundamental rights, what is the definition of a state and why is this definition so important, what is judicial review, and the first fundamental right, the right to equality. In the context of Article 13, we will also look at the doctrines of Eclipse, Severability, and Waiver. The Constitution of India guarantees 6 categories of fundamental rights: right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, right to constitutional remedies. Sometimes there is a misconception or a misunderstanding that every fundamental right corresponds to one article. This is not true. As you can see here, the right to equality itself is addressed by 5 articles, 14 to 18. This is because there are different aspects of each fundamental right that needs to be addressed specifically and separately. All fundamental rights are guaranteed to all citizens of India, and some fundamental rights are also available to non-citizens also, as long as these non-citizens are on Indian territory. Some fundamental rights are intended to limit the government's powers of legislation or give directions to the government. For example, Article 24 prohibits the employment of children in factories, which is more of a direction or an instruction to the government to ban child labor. Now, why are fundamental rights included in the Constitution? Fundamental rights are meant to achieve 2 objectives. First, to ensure individual freedoms, and second, to protect individuals against the arbitrary and absolute exercise of power by the state. In fact, most fundamental rights are mainly available against the state. If we are saying that fundamental rights are intended to protect the citizens from arbitrary actions of the state, and that these rights are mainly available against the state, then it becomes very important for us to have a clear understanding and a clear definition of what is the state. Article 12 of the Constitution gives us a definition of the state. It says that unless the context requires otherwise, the central government, the parliament, the state governments, the state legislatures, and all local or central authorities come under the category of state. Now, remember this part, unless the context otherwise requires. I will shortly tell you about why this part or this phrase is very important. The broadest definition of the term state is that it is the government, which means legislature at state and central levels, the executive at state and central levels, and local authorities such as municipalities, panchayats, and other government agencies. While some of these, such as the legislature and the executive, are very clear, in case of some organizations or entities, it becomes difficult to ascertain whether they fall under the category of state or not. For example, UGC comes under the definition of state, but till recently, NCERT did not come under the category of state. But after the NCERT was given a deemed to be a university status, it started to come under the definition of a state. So the concept of a state can be somewhat vague. In its decision in the Ajay Hasia versus Khalid Mujib case, the Supreme Court listed out a set of tests which can be used to determine if an organization or an entity is to be considered as a part of the state or not. Such as, we need to see whether the entire share capital of the entity is held by the government, or the financial assistance of the state meets most of the expenditure of the entity, or the entity enjoys a monopoly status which is either conferred or protected by the state, or the existence of deep and pervasive state control, which means that the state controls many aspects or all aspects of the entity, and the functions of the entity are of public importance and closely related to government functions, or an entire department of the government itself is transferred to the entity. In any of these situations, the corporation or the organization or the entity will be considered to be a part of the state. If an organization is considered to be part of the state, then most fundamental rights will be available against it. Before we move on, let us take a look at Article 12 again. You will see that Judiciary is not mentioned in this article. So, does the Judiciary come under the category of state or not? Also, remember I mentioned that this phrase, unless the context otherwise requires, is significant. This is actually relevant in deciding on the status of entities which perform multiple functions in different contexts. For example, the Judiciary performs two types of functions, judicial and non-judicial. In the A.R. Antule versus R.S. Nayak case, the Supreme Court clarified that when a court is performing its judicial functions, then it is not part of the state because it cannot infringe on the fundamental rights of people in this context. But when the court is performing non-judicial functions, then it can potentially infringe on the fundamental rights of people. Therefore, it will be considered as a part of the state. So, while deciding whether an organization comes under the state or not, the context of the organization or the entity's functions should be taken into consideration. In simple words, the type of work that the organization does will determine whether the entity falls under the category of state or not. As we can see, the Constitution gives a lot of importance to fundamental rights. So, if they are so important, can these fundamental rights ever be suspended? The answer is yes, and in fact, they were suspended thrice. First time was during the India-China War in 1962, and the second time was during the India-Pakistan War in 1965, and the third time was during the emergency declared by Indira Gandhi in 1975. Before the 44th Amendment of the Constitution, all fundamental rights could be suspended during an emergency. But due to the events which happened during the 1975 emergency, the 44th Amendment was made to the Constitution in 1978. After this amendment, the fundamental rights under Articles 20 and 21 cannot be suspended even during an emergency. So currently, as per Article 358, if a national emergency is declared, then the 6 fundamental rights under Article 19 are automatically suspended. The fundamental rights under Articles 20 and 21 will remain enforceable even during an emergency. And under Article 359, the President can also suspend the right of citizens to approach a court for enforcement of fundamental rights, except for the enforcement of rights under Articles 20 and 21. While studying various law subjects, you would have seen that India has several laws that are older than the Constitution itself. These are laws from the days of the British Empire, and some of them even date back to the 1800s, and many of these old laws are valid even today. When the Constitution was enacted, this specific situation as to what is to be done with these pre-constitutional laws was addressed in Article 13. Article 13 simply says that if any part of an old pre-constitutional law is not consistent with the fundamental rights guaranteed under Part 3 of the Constitution, then that conflicting part of the law will be void. It also says that the government will not make any new laws that conflict with fundamental rights. This article also provides an escape clause or some flexibility to the government by saying that this article is not applicable to any amendments of the Constitution. On the basis of this article, there are 3 doctrines that we can look at: Eclipse, Severability and Waiver. And we will also look at the concept of judicial review. You know about eclipses. During a solar eclipse, the moon comes between the sun and the earth, which means that the sun is eclipsed. It did not go anywhere. It is still where it was and where it should be. It is just temporarily hidden by the moon. When the moon moves away, then the sun will fully become visible again. Using the same analogy, the doctrine of eclipse says that if a pre-constitutional law conflicts with the fundamental rights, then the law is obscured, hidden or eclipsed by the fundamental rights. If the Constitution is amended to remove the conflict, then the entire law will become visible again. What we have to remember is that the law does not become void ab initio. It has only been eclipsed after the Constitution has been enacted. So any rights or liabilities that were acquired because of such pre-constitutional law will continue to be valid. Only new rights or liabilities cannot be created by this law when it is eclipsed. Once the eclipse is removed, then the law will become fully valid again. To sever means to cut or to separate. The doctrine of severability says that if there is a pre-constitutional law and a part of that law conflicts with the fundamental rights, then such a conflicting part can be severed or separated from the rest of the law. If the remaining part of the law is able to function even after the conflicting part is severed or separated, then the remaining part of the law will remain valid. To waive means to relinquish or give up. The doctrine of waiver holds that a person has the right to waive his or her rights. For example, if I go to a movie theater and I find someone else sitting in the seats that I have chosen, then I can either choose to enforce my rights or I can choose to waive my rights and sit somewhere else. Now the basic requirement here is that the person who is waiving his or her rights should be legally competent. So minors or persons who are unable to take a competent legal decision, they cannot waive off their rights. The waiver can be explicit or it can be implicit through actions. The waiver must be voluntary and not forced. And once a person waives a right in a specific situation against a specific person, then the same right cannot be enforced again at a later stage. For example, if I have the right to receive rent from my tenant on the first of every month, but if I tell him it's okay even if you pay later, then I am waiving off my rights. And once I have waived off my right, I cannot later on ask him to pay any interest or penalty because of the delayed payment. The current legal view is that as a matter of public policy, fundamental rights cannot be waived off. Any other rights that a person has can be waived at his or her choice. Next, let us take a look at the concept of judicial review. This concept is actually quite simple. It just means that all actions of the state can be subject to judicial review. In fact, in the Indira Nehru Gandhi versus Sri Rajnarayan case in 1975, the Supreme Court held that judicial review is a part of the basic structure of the Constitution itself. So, what actually happens during a judicial review? Well, a judicial review can check for any violation of fundamental rights or violation of any other articles of the Constitution or any other laws, or if the state is exercising any powers that are not conferred on it by the Constitution, or if the state is misusing any of the powers conferred by the Constitution, or if there is any misunderstanding or misinterpretation of the Constitution or any other laws. The concept of judicial review is built into the Constitution under several articles. Specifically, in the context of Article 13, a judicial review can check if an action of the state is conflicting with or violating any fundamental right. If there is a conflict or a violation, then such an action of the state is invalid. And if there is no conflict or violation, then the actions are valid. Next, we will look at the right to equality that is guaranteed by Articles 14 to 18. Each one of these articles addresses one specific aspect of equality. As declared by the Supreme Court, equality is one of the basic features of the Indian Constitution, which means that any amendment to the Constitution or any legislation or any other action by the state that conflicts with the right to equality will be invalid. Article 14 says that every person will be treated equally by the law and will be protected equally by the law. This right is available to both citizens and non-citizens within the territory of India. This is also available for juristic persons, such as a company. While the Constitution prohibits class legislation or discrimination, classification is allowed. Now, what is the difference between these two terms, classification and class legislation? Well, classification is like sorting fruits into different baskets based on the type of fruit. For example, apples, oranges, bananas. You sort them into different baskets for easier selling. There is a valid and a logical reason for this classification. Now, class legislation is like allowing only one type of fruit to be sold in the market without any valid reason, which means that you are discriminating against the other fruits. Classification should be legal. It should be on the basis of a valid criteria and it should be for a reasonable purpose. In several landmark cases, the Supreme Court has given judgments about classification, and it has also laid down some tests to determine if the classification is valid or not. The classification should be based on rational and reasonable factors, such as the place where people reside, that is geography, or on the basis of a particular occupation, like fishermen or farmers. The factors and the reasons for classification should be for a specific objective. For example, if the government reserves some seats in schools for citizens living in remote areas of the country, then the classification is valid because it is based on geography, that is, remote areas of the country. And the reason for this classification may be because such geographical areas, the remote areas, do not have good educational facilities. And the objective of this classification may be to address the lower level of education among people living in such remote areas. Another example could be when the government classifies people on the basis of their family income and provides scholarships or mandates lower fees for the economically weaker section. This will be considered as classification based on a valid and reasonable criterion, that is, economic status, and for achieving a valid objective, that is, to ensure that the weaker economic status does not become a barrier for education. Article 15 says that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. The article also provides some exceptions where the state can make some specific provisions such as reservations for the advancement of women and children, or for socially and educationally backward classes, or for scheduled castes and scheduled tribes, and for economically weaker sections. One interesting fact here is that this discrimination based on place of birth is invalid. It is written in Article 15 itself. But discrimination based on place of residence is valid. In a 1955 case, a medical college was collecting capitation fee from out-of-state students, whereas students residing within that state were exempt. And this case went all the way to the Supreme Court, and the court decided that discrimination based on place of residence is valid. Article 16 talks about the equality of opportunity in matters of public employment, that is, equality of opportunity when it comes to government jobs. There are some exceptions that are provided, such as reserving jobs on the basis of residence in the state or in the union territory, or reservation for any backward class of citizens, or reservation in promotions in favor of scheduled castes or scheduled tribes, or in case of religious institutions, reserving an office for a person following a specific religion. For example, reserving the job of the head of a temple to a person who follows Hinduism, or reservation in favor of economically weaker sections of citizens. Article 17 talks about another aspect of equality, that is, abolition of untouchability. Now this is quite self-explanatory, so there is no need to discuss this in depth. But an interesting case law here is Devarajaya versus B. Padmanna, where the court declared that social boycott of a person is not untouchability. It is an interesting case, so just Google it and read the judgment when you have some time. And finally, Article 18 talks about the abolition of titles. Now, what are these titles? Well, during the British Raj, the state was giving out titles such as Sir, Rai Bahadur, Khan Bahadur. Now, this article says that the Indian state will not confer any titles except military or academic distinctions. It also says that any person who is not a citizen of India but is officially working for the Indian state will not accept any foreign titles without the consent of the Indian president. And any person who is officially working for the Indian state will not accept any money, presents, or job of any kind from any foreign state. So this essentially prevents any conflict of interest. Now, a point to note here is that titles should not be confused with awards or recognitions. Now, the Bharat Ratna, the Padma Vibhushan, Padma Bhushan, Padma Shri, Khel Ratna, these are all awards or recognitions, and these are not titles. Now, titles create a specific class of persons, such as all Rai Bahadurs or all Khan Bahadurs belong to one class, whereas awards are a recognition of merit or achievements. With that, we come to the end of this part. If you have any questions or feedback, post a comment. And I will see you again in the next part of this series. Till then, take care, stay safe.